Good evening again. I'd like to call this meeting to order, the regular board meeting, Tuesday, October the 9th, 2012. The time is 7:06. Item number 1, call to order, roll call, establish quorum. We do have a quorum, which brings us on to item number 2 and 3. Pledge of allegiance to the U.S. and Texas flags and invocation. This evening we do have students from Berta Cavazza Middle School joining us. And Mr. Snavely has brought in 2 of his fine students, Andrea Saldana. Andrea Saldana is currently an 8th grader at Berta Cavazza Middle School. She is the daughter of Noe and Araceli Saldana. She serves as secretary of the National Junior Honor Society. She participates in extracurricular activities such as dance and volleyball. And in her spare time, she likes to read, listen to music, dance, and spending time with her family. Her future goal is to become a pediatrician because she loves helping and working with children. We also have Julian Huerta. Julian Huerta is currently an 8th grader at Berta Cavazza Middle School. He is the son of Mr. Julian Huerta and Miss Mary F. Gonzalez. He currently is a member of the National Junior Honor Society, plays baseball, basketball, and football. He also helps out with yearbook and band members at school and family members at home. He also volunteers his time as an altar server at church. When he gets older, he wishes to major in marine biology and minor in music. His ultimate goal is to play professional baseball. If I can please have these 2 students stand and be recognized, as well as their parents if they're in the audience. If I can have everyone please stand for the Pledge of Allegiance and the invocation.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Under the Texas flag, I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Now let us bow our heads. Dear Father, we pray to you today for gathering us together to make the best decisions for the children of our community, to strengthen our board members and guide them to make the correct decisions to make our schools a better place to raise and educate the children of our town, to help the children make something of their lives, to better our community, to make it a good, safe, and healthy environment to live in. We ask, Lord, that you bless, guide, and protect each and every one here present, and that you return us to our homes safely. We ask this of you in Jesus' name, amen. Amen.
And again, thank you to Mr. Snavely for inviting these 2 students here tonight, and the parents as well for bringing them. Moving on to item number 4, roll call. Please respond with present. Ms. Ana Cruz, Vice President. Present. Ms. June Aguilera, Secretary. Present. Ms. Fatima Huerta, Trustee. Present. Mr. Julian Huerta, Trustee. Present. Mr. Hector G. Leal, Trustee. Present. Mr. Oscar Medrano, Trustee. Present. Mr. Antonio G. Limon, Superintendent. Present. Mr. Kevin O'Hanlon, School Attorney. Item number 5, recommend approving the agenda of the regular board meeting of October the 9th, 2012 with any corrections or deletions. We have a motion by Ms. Aguilera. Do I have a second?
Second.
Seconded by Mr. Huerta. All those in favor?
Aye.
All those opposed? Motion carries. Item number 6, Superintendent's Report. Mr. Limon.
Thank you, Madam Chair. At this time, Governor of Texas Rick Perry has proclaimed October 2012 as Principal Recognition Month. And in his proclamation, he reads, as school leaders, principals are entrusted with our most valuable resource, our young people. These students are our promise for the future, and it's absolutely critical that they receive a rigorous and well-rounded education. Principals are more than just caretakers of their schools. Principals are expected to be educational leaders, disciplinarians, community builders, spokesmen, budget analysts, guardians of policy mandates and initiatives. Principals set the academic tone for their school, and they work together with the teachers to maintain a high curriculum standard, develop mission statements, and set performance objectives. The National Association of Elementary School Principals and the National Association of Secondary School Principals, joined by the state affiliate of the Texas Elementary Principal and Supervisors Association and the Texas Association of Secondary School Principals, have designated the month of October as a time to recognize the contributions of elementary, middle, and high school principals. This time, I encourage all Texans to recognize the important role principals play in ensuring that every child has access to a high-quality education. Therefore, I, Rick Perry, Governor of Texas, do hereby proclaim October 2012 to be Principals Month in Texas and urge the appropriate recognition whereof, in official recognition whereof, I hereby affix my signature this 4th day of September 2012, signed, the Honorable Rick Perry, Governor of the State of Texas. Will all our elementary, middle school, and secondary principals and assistant principals that are present please stand? Mr. Snavely, you can't stand. Mr. Snavely, you can't stand up for longer than 2 seconds.
On behalf of the board, thank you to all the principals. I know it is a difficult and challenging job, but I know that you all do it with the best interest in mind for the students, and you do it with all your heart. So thank you to all the principals and assistant principals on each and every campus.
Yes, I will repeat what the president has said. Without you, it would be impossible to run this district. You do a tremendous job. I realize that you're overworked and underpaid, but you are appreciated. So thank you very much for what you do. We also have disbursements and disbursements by organization. That would conclude the superintendent's report. Thank you, Madam President.
Thank you, Mr. Limon. Moving on to item number 7, public comment. The undersigned wishes to address the San Benito CISD Board of Trustees, and by his or her signature shows into the board that he understands the following provisions to addressing the board. The person wishing to address the Board of Trustees must register with the presiding officer or designee no later than 5 minutes before the announced time of the school board meeting, shall state their full name, shall state what organization or group, if any, is being represented, shall state the topic they wish to address before the school board, shall refrain from commenting directly on any individual school district employee or public official by name, but may instead refer to a specific employment area, job title, or the Board of Trustees as a whole, and shall refrain from attacks on individuals. The person wishing to address the Board of Trustees should do so in accordance with the following San Benito CISD Board Policy, BED, guidelines. The speaker will be allotted 5 minutes to give his or her presentation. Delegations of more than 5 persons shall appoint 1 person to present their views before the Board of Trustees. Presentations shall be informative and shall pertain to school-related issues. Any attack on an individual shall be considered disruption of the meeting. The Board of Trustees shall not deliberate or decide regarding any subject that is not included on the agenda posted with the notice of the meeting. This evening, we do have 4 individuals in our audience who wish to speak before the board, and I'd like to ask that Mr. Jose Garcia please come forward. His topic, the flag of the United States.
Thank you very much. Well, let me get up here. I thought I'd be able to stand, but I think I'm going to pass this time. Can you hear me? Yes, I'm Jose Garcia. I was born in San Benito. I graduated from Frank Roberts Elementary. Milo Jordan was my principal. Berta Cavazza was my homeroom teacher, so you can tell that I've been around for a long time. I've been a football fan, San Benito Greyhound football fan for 57 years, but that's not the reason I'm here. I'm on a mission here, good people, but let me qualify why I'm here. I have served under 6 presidents of the United States. I'm an American patriot. I'm a wounded veteran from the Vietnam War. I operate under the 3 M's, mission, men, and me. The men are gone, they're dead, the mission is not yet complete, and I'm it right now. To no fault of anybody here, the American flag at the stadium is on the wrong side of where it should be. Now, I'm not going to go into who has been going back and forth with me on this, because that's not what it is about. It's not about you, Limon, or me. This is about the United States of America and what the American flag represents. The American flag represents freedom, justice, and the American way. Everybody knows that. But what people don't know is that it also represents something else, the cost of freedom. You've got a flag there with 7 red stripes, 6 white ones, 50 stars. You know how I know that? I have one in my bedroom hanging right there. That's how much I love this country. That's how much respect I have for the American flag. Now, when I said that the flag was on the wrong side, it's true. The American flag should be to the right of front. Looking at it from here, and where you are the front. The American flag is to your right. Now let's put it over here, where the American flag is at the stadium. Now, is it to your right? No, it's wrong. That's where the American flag is, to the right of the back of the building. That is totally wrong. That is, I'm sorry, I get very agitated. I'll say agitated instead of upset, because I see that. I no longer go to the games. I'm ashamed. I'm not blaming you, Limon. Nobody here is at fault. The architect did not know where to put it. He told me that when I first approached him before even the stadium was complete. Nobody did anything about it. I told her, right there, Celeste, tampoco. The other people that were here as board members, nobody did anything. Doesn't anybody care? I mean, no, that has nothing to do with you and me. That's the truth. You put the American flag on the right of the ticket office, it's got to be to the right of the front of the ticket office, not to the right of the back of the ticket office. That's wrong. That's sacrilege. The red on that flag, that's the price of freedom. That's the blood of every single American man and woman and wounded individual that has died and given everything for you and you and you and you to be here free. Hey, that merits respect and honor. It has no business being used by you or by me, because I know I did wrong in going. That was the wrong route. It was, because this is not about you and me. This is about the American flag and those that she represents. Hopefully, like I said, I operate under the 3 M's, mission, men, and me. The men are dead. The mission is not yet accomplished, and I'm the only one left. Hopefully, everybody here will rally around me and will take care of this problem. We have a beautiful stadium there. Oh my God, man, if the flag would be flying on the right place, it'd be fantastic. That's all I have to say. Thank you for your time.
Thank you, Mr. Garcia. Next, we have Mr. Jesus Aguilera.
How do you follow that? You know what? He's probably right. Well, I know he's right. And maybe you guys will take care of it before he dies. Okay? Because I guess he really wants it, or he wouldn't be here. Let me tell you again. I'm here because, again, bouncing babies, pre-K program, gone. And they're still gone. I'm going to come here every month, and I'm going to tell you what's gone. 2 months ago, I asked you, let's do the right thing. What did we do? We voted 4-3 in favor of the higher premium, insurance premium for our employees. It took this man to fix it. All of you failed. Well, 4 of you failed. This man took care of it the next day. That's not his job. It's your jobs. And again, the agent helped. Let me tell you about the agent. You guys wanted to pay him $104,000 last month. You should look at the film. It's on YouTube. Thank God we didn't pay him $104,000. $195,000 was overpaid. The consultant found the error, and right now they're working on getting that money back to the district. $195,000. Let me tell you the worst thing. The superintendent took care of the higher insurance premiums. But let me tell you what happened. $44 a month and 100% coverage could have been given to all the employees here of this district. And you know what we did? We didn't do anything about it. We just let it go. People could have had $44 in their pockets and had 100% coverage. But the consultant, you didn't go with the recommendation. I'm going to say something really quick about the letter, because we all know about the letter. Let me tell you about the letter. The board president was not by herself when that letter was discussed and drafted. All right? And it happened at Chili's. So just so you know, $90,000 is paid to a person here that sells software to its district. Another person is paid over $94,000 to go around telling kids that Chuy's Custom Sports don't care about their program. Let me tell you, he doesn't know this, but my little girl is in that program. So I do care. And even if she wasn't, I would care. $13,000 raise, one person. Okay, one board member decides that how much he should get. And let me tell you what that person that got that $13,000 raise did. She went and hired Lucha. Okay? And let me tell you who is a presenter for Lucha. Okay? Just so you know.
Mr. Aguilera,
Almost time?
your 5 minutes are up.
Okay. Well, next month I will come and tell you about the sexual harassment, sexual misconduct with students, and I'll have that for you next month. Thank you.
Thank you, sir.
Diablo, you're right.
Next, we have Rafael Chacon. Topic, Dolly Vincent Hospital.
Good evening, Board, Mr. President. As you mentioned, my name is Rafael Chacon. I'm a developer I live in Brownsville. I'm one of the bidders. I represent a group, but we're one of the bidders, higher bidders, for this last bid for Dolly Vincent Hospital. I just wanted to see if I had permission, Mr. President, to give some little brochures of my business and what projects we have accomplished in Brownsville. And wanted to see if there are any questions, if that can be done.
Mr. O'Hanlon, can we accept the brochures he's offering?
You can make a presentation in 5 minutes if you want to.
But can I deliver these brochures?
Can he
These brochures?
hand them to the board members?
Okay, thank you. Well, again, I just wanted to present myself here and definitely feel Dolly Vincent and San Benito needs to be opened again. We definitely are thinking about doing something health-related for this property. We understand that it has a lot of history, and we really want to do something for the community, for San Benito, and we know that obviously school district has some of the tax dollars that are going to there. That's part of what that's all about. But again, we want to go in there and do something health related and obviously invest some money and hopefully create something productive for your tax monies that come into your school district. Again, those brochures explain a little bit of what I do personally in Brownsville. I have a group of investors that I'm representing, and again, I wanted to make myself known, and my information is there in case there are any questions. Thank you very much.
Thank you. And we have one more audience member, Rosalinda Garcia, and this is regarding the fan club.
Good evening. I'm not as good a speaker as Mr. Aguilera, but I'm a member of the fan club. That's a new organization with the city of San Benito, and I'm here to invite you all to attend. It's a positive fan club. It's not with the school district, like I said, it's with the city, and we're promoting team spirit, and not just with football. We're going to try to do it the whole year through, and it's something we're attempting to carry on. It's been placed in the paper, and all of you would be welcomed, and we hope to see you all there. We would really love to see you all there to attend, and like I said, everyone would be welcome. Right now we're collecting food cans, maybe a scholarship later on, and we're having it at a local print shop. He offered his building. We had another building in mind, but it didn't work out. So that person offered his building. We have music, we give out prizes, so we hope to see you all there. And like I said, it's in the paper and everybody's invited. And we hope to see you all there if you can support us. Thank you.
Thank you, Ms. Garcia. That brings us on to item number 8, school construction report. Mr. Ramon.
Buenas noches. Have 3 projects left in the 2008 bond. Frank Roberts and Landrum Elementary. The contractor is working to complete the punch list. The architect punch list, he has about 90% of it completed. To my knowledge, he has not begun to work on the civil punch list, and civil meaning the parking lot, sidewalks, things like that. And so he's working with that. There's a couple of issues that are working with on the hoods on both of the projects on the kitchen. At Frank Roberts and Landrum, HVAC upgrades, test and balance should be completed by the middle of next week. And the contractor will, by the end of next week, will be able to finish with all their punch list items. Are there any questions?
Thank you, Mr. Ramon. Item number 9, action agenda. In order to promote efficient meetings, the board may act upon more than one item by a single vote through the use of consent agenda. Consent items placed on the agenda shall be marked with an asterisk. Consent items are items for which no board discussion is anticipated and for which the superintendent recommends approval. Prior to the time which approval of consent agenda is had at the request of any member of the Board of Trustees, any item on the consent agenda shall be removed and given individual consideration. And we'll begin under Business and Finance. Item 1210A-1, request for approval of acceptance of the substantial completion of the HVAC upgrades project at Frank Roberts Elementary School. Consent. 1210A-2, request for approval of acceptance of the substantial completion of the HVAC upgrades project at La Paloma Elementary School. Consent. 1210A-3, request for approval of Emma McCall as investment officer for the San Benito CISD. Consent. 1210A-4, request for approval of resolution approving annual review of the investment policy and investment strategies. Consent. 1210A-5, request for approval of resolution approving independent sources of instruction relating to the investment responsibilities. Consent. 1210A-6, request for approval of 2012-2013 budget amendments. Consent. 1210A-7, request for approval of budget transfers. Consent. Under Curriculum and Instruction, 1210A-8, request for approval to accept the Technology Lending Program Grant Award. Consent. 1210A-9, request for approval of San Benito CISD Internet Acceptable Use Policy that requires the district's filtering of Internet access and implementing certain Internet safety measures to comply with Children Internet Protection Act, CIPA. Consent. Under Administration, 1210A-10, request for approval of board minutes. Consent. 1210A-11, request for approval of the 2012-2013 class size waiver. Consent. 1210A-12, request for approval to update board policy FNG local.
I have a real quick question on that one.
Question by Ms. Aguilera. Okay. I'd like to ask for a motion to approve items 1210A-1, 1210A-2, 1210A-3, 1210A-4, 1210A-5, 1210A-6, 1210A-7, 1210A-8, 1210A-9, 1210A-10, and 1210A-11. Motion made by Mr. Medrano.
Second.
Seconded by Ms. Aguilera. All those in favor?
Aye.
All those opposed? Motion carries. Brings us back to item 1210A-12, request for approval to update board policy FNG local. We have a question by Ms. Aguilera.
Yeah, my question, I had worked that day, so I let one of my.
You want to turn on your own mic, Ms. Aguilera? Turn on your mic.
Sorry. Like I was saying, I had worked that day, so I let one of my members conduct the meeting. And I just wanted to ask a real quick question about, I know that it goes to the school now, which I have no problem with, but I just wanted to know who would make the final decision, if it would be an agreement amongst the principal and the director of that program, or just the principal, because I just want to, if you have a director for a reason is, to give input. So I just didn't know, who it came down to was going to make the final, if it's two people or if it was one.
Mr. Franco, can you, Board President has asked if you'll give us a quick overview of the policy for the board members that weren't present?
Ms. Aguilera, with regard to that question that you had, the person that would have the level 1 grievance will be the administrator that has the authority to make a decision to remedy that grievance. Typically, that's going to be the principal of the campus. So that would be just like any other grievance that is conducted at level 1. It's 99% of the time it's done by the principal.
So like the director will have no?
No, this, unlike, for example, the Constitution, which you're probably, considering, the Constitution does have a sponsor and principal making the decision. However, if they made a decision together, once the person files a grievance, that grievance would be held by one administrator, typically, again, the principal, who would make it by themselves, and it would end right there.
Now, just in case you run into the problem that if the principal is involved, then where does it go? Who makes the decision from there? Like if the principal is involved with it?
Well, the principal can, have a designee that they assign, and that's why I'm saying that it
And
could also.
that's by their choice?
It would be their choice, but again, typically that's not been the case. It's typically almost all the grievances I've ever seen from level 1 are conducted by the principal.
That was just my question, because
Is that it?
Thank you, Mr. Franco.
I'll make a motion.
Okay. I have a motion by Mr.
I
Medrano
move, excuse me, I move to approve the item.
to approve item 1210A-12. Do I have a second? Seconded by Mr. Leal. All those in favor? All those opposed? Motion carries. Item number 10, closed meeting, discussion under the authority of the Texas Government Code 551.071 for the purpose of a private consultation with board's attorney on any or all subjects or matters authorized by law. A, discussion of R. Atkinson lawsuit cause number 2008-08-003278, settlement agreement. B, consultation with attorney regarding legal issues raised in parent and/or student or employee grievances. 551.072 for the purpose of discussing the purchase, exchange, lease, or value of real property. A, review and discussion of private offers on the sale of delinquent tax properties. 1, legal description. Tract 1, known as the former Dolly Vincent Hospital, 7.178 acres, more or less, being a portion of the southeast quarter of Block 81 San Benito Land and Water Company Subdivision, Cameron County, Texas, as described in deed dated November 7, 2008, United States of America to the San Benito Enterprises, LLC, in volume 15567, page 191, deed records of Cameron County, Texas, account number 88-5270-0810-9000-00. 2, legal description. Tract 1, all that certain tract of land being a portion of Block 167, San Benito Land and Water Company Subdivision, Cameron County, Texas, described as 4115 acres, more or less, in deed dated November 22, 1971, from Luis Izaguirre, ETUX, to Clemente Izaguirre in volume 925, page 260, deed records of Cameron County, Texas, save and accept, however, that certain 1 acre tract described in volume 1338, page 471, deed records of Cameron County, Texas, leaving here a residue of 3.115 acres, more or less, account number 88-5270-1670-0700-00. 551.074, for the purpose of the appointment, employment, evaluation, reassignment, duties, discipline, or dismissal of a public officer or employee, to hear complaints or charges against a public officer or employee. A, personnel reports. 551.082, school children, school district employees, disciplinary matters, or complaint. 551.0821, personally identifiable information about public school student. A, Level 3 grievance, FNG Local, Yolanda y Trevino, conduct hearing if grievant requests hearing to be held in closed meeting, or if board determines hearing shall be held in closed meeting. Deliberate on grievance if the grievance is held in closed meeting. B, Level 3 grievance, FNG Local, Colleen Duncan, conduct hearing if grievant requests hearing to be held in closed meeting, or if board determines hearing shall be held in closed meeting. Deliberate on grievance if the grievance is held in closed meeting. C, Level 4 grievance, DGBA Local, Gina Jones, conduct hearing if grievant requests hearing to be held in closed meeting, or if board determines hearing shall be held in closed meeting. Deliberate on grievance if the grievance is held in closed meeting. And D, Level 4 grievance, DGBA Local, Blanca J. Gonzalez, conduct hearing if grievant requests hearing to be held in closed meeting, or if board determines hearing shall be held in closed meeting. Deliberate on grievance if the grievance is held in closed meeting. Okay, Mr. O'Hanlon?
Your choice, we can, it's my understanding that a couple of the grievances want to open. We have some issues that need to be resolved in closed. We can step out and do the real estate matter and the Atkinson, and then come back and get the grievances, and then go back. Might be the most efficient way. I don't think either one of those items will take very long.
Okay, we'll go ahead and do that, take care of those items, and then we'll come back and reconvene for the grievances.
Let me ask one question from the folks that are here. Is Ms. Trevino here? Ms. Trevino here? Yes? You wish thank you. Do you wish the grievance to be held in open or closed? Pardon me? Closed. All right. Ms. Duncan? Is closed. We can do those. Is Miss Gina Jones or her representative here?
I think I had put open. I think I had put open.
Open or closed on that? Open?
Yes.
All right. Ms. Gonzalez, or her, open. So we can go do the two student matters, and while we're out, and then come back and finish the other two? If you want to do that, that way we can get real things out of here.
So we only have one in closed session, correct? We have
Ms.
Trevino in
Trevino
open?
Wasn't it open?
She wants, yeah.
I think she said closed.
Do you want it open or
Ms.
closed?
Trevino, did you want your grievance to be held in open or closed?
She wants it in the open?
Open?
Yes.
I'm going to advise you that you cannot, while you can waive the family educational, this is involving students, and while you can waive the Family Educational Right and Privacy Act for your own child, you cannot mention other students in this grievance. You understand that?
Yes.
Right? So we can do the one.
Okay. We're going to go ahead and go into executive at this time. It's 7:42, and then we'll reconvene to hear the other grievances. Okay, good evening. The time is now 10:03, and we are reconvening an open meeting. Item A, discussion, possible action of R. Atkinson lawsuit cause 2008-08-003278 settlement agreement.
Madam President, I move that the board accept the settlement in the Atkinson lawsuit as discussed by council.
Second.
We have a motion to accept the settlement offer by Mr. Medrano, seconded by Ms. Aguilera. All those in favor?
Excuse me, point of order, point of order.
Commissioner O'Hanlon?
Point of order, I did forget on the motion also, I do want to add that we want to authorize the president to execute the settlement papers. I'd like to add that to the motion, please.
Okay. We have a motion to accept the settlement offer and allow the president to execute the agreement. I have a motion by Mr. Medrano, seconded by Ms. Aguilera. All those in favor?
Aye.
Aye. All those opposed? Motion carries. Moving on to item B, discussion and possible action on the resolution approving the private offers received from the referenced properties. 1, legal description. Should I read the whole thing again? No? And 2, legal description on both properties for the Dolly Vincent Hospital and the tract of land being a portion of Block 167 of Ohio Station Road.
Madam President, I move that the board accept the offer that on the Dolly Vincent Hospital property that was accepted by the city with the amount of $286,690.41.
I second that.
We have a motion to accept the offer for the Dolly Vincent Hospital by Ms. Cruz, seconded by Mr. Leal. All those in favor?
Aye.
Aye. All those opposed?
Nay. Sorry.
Okay. We have one opposed.
Me.
I have, Madam President, I move that that the board accept the offer for the portion Block 167 in the amount of $1,901.42.
I second.
We have a motion to accept the offer for Block 167 by Mr. Leal, seconded by Ms. Huerta. All those in favor?
Aye.
Aye.
All those opposed? Motion carries. We did hear 2 grievances in closed session. Level 3 grievance, FNG Local Yolanda E. Trevino, and we also heard the grievance, Level 3 grievance, FNG Local for Colleen Duncan. And there's no, right, Mr. Lima? And with regards to those 2 grievances?
All right. Under district policy, FNG local, if there's no action by the board, the decision at level 2 is okay.
Okay, with that said, we still have 2 grievances to be heard. Level 4 grievance, DGBA local Gina Jones, and level 4 grievance, DGBA local Blanca J. Gonzalez. Mr. O'Hanlon?
You want to hear Jones, is that C? Which one you want to do first? C, all right. Gina Jones?
John Sherrill representing Mrs. Jones to request the grievance to be held out in the open, please.
All right, let me set this up, council. It is 10:06. It is the 9th of October, 2012. The board is in open session and is in a lawfully called meeting and is here to hear the decision at level 4 of Gina Jones. The board has before it the grievances at prior levels and the decisions below in the record before them. They also have a transcript, in this case, of the court reporter's transcript of the hearing. I can give you a, do you have a copy? Do you have a?
No, I do not have a copy of the transcript.
Sure. We just got these this afternoon. I was giving it to you earlier.
Thank you very much.
The board policy is to allow 10 minutes for presentation. I can give you a warning, if you will, at whatever time you want. After you finish your presentation, they may have some questions.
Very well. May I proceed?
Yeah, how much, do you want a warning, or are you going to keep your own time?
You can give me a warning, Mr. O'Hanlon. I guess a 2-minute warning like they do in football games. I'll take a 2-minute warning.
All right, sir. I will do so.
Thank you. Ladies and gentlemen of the board, my name is John Shergold, and I'm always honored to represent school employees and workers. I've been doing it for many years. And tonight I represent a fine lady here, Mrs. Gina Jones, who's been a dedicated employee and classroom teacher of the school district. You know, when I come in front of the board, I always usually come in here usually 21-0 behind. And that's basically means that when I come in here, it usually means that the administration's already ruled against me, and I have to come in here and try to make a first down, and it's 4th down and 30. So I'm going to try to do that tonight, and I'm going to try to explain why I think that we're right. Now, Ben Franklin said, a person convinced against their will is of the same opinion. I hope that I can make an argument and you'll hear it and you'll say, you know what, I understand what he said, and I think I'm going to go ahead and agree with him, even though maybe it's not what I think the administration thought was supposed to happen. You're lawfully elected by the citizens of this great school district, and I trust that you'll listen and carefully what I have to say. Let me just go ahead and talk about why we're here. Under the Family Medical Leave Act, it was basically brought to us by President Bill Clinton, President Clinton had the wisdom to bring this statute into effect, and Congress passed it back during his administration. The Family Medical Leave Act basically says that if an employee is somehow has a serious medical injury or a consequence, or has a family member who's got injured or has some sort of medical problem, or whatever it might be, that person or employee can take a leave off for a specified number of days. I think President Clinton was right. I think that was a great law he passed, and it's still being used today. Ms. Jones took leave under FMLA, and she took that leave applied for around May the 14th, 2012, and then around August the 14th, 2012, at Riverside Middle School, her position as English Language Arts and Reading, where she was there in that position, she learned on August the 14th that, well, guess what? Her position was going to be changed to a theater arts position. And when she comes back here in the next week or so, she's been reassigned by her principal to the theater arts position. Now, of course, you know, the school district's administration has argued that under Chapter 29 United States Code that the jobs pays the same, and that, in other words, the statute has been complied with. That's what the administration's argument is going to be, and that's what it's always going to be. However, we have a different position on this. The statute says it should be returned to an equal position with equal or equivalent benefits. Now, the equivalent benefits, we can't dispute is not the case here. We understand that she's coming back with equal benefits. But the equivalent position is not what she's coming back to. She's going to a theater arts position. She was an English language arts and reading position. Statute says she has to come back in an equivalent position. Well, if you compare the position of English language arts and reading to theater arts, they're not equivalent at all. As a matter of fact, I try to make that argument at level 2, but again, you know, sometimes we can't convince, as Ben Franklin said, we can't convince someone against their will of the same opinion. So with that in mind, let me just compare the positions. Under the English arts and reading position that Ms. Jones was at during the 2011-12 school year, she was basically accountable under the STAR accountability. She was only teaching 6th grade level. She had 2 conference periods. She had team playing, sharing, lesson plans. She used C-scope. Her classes schedules broke into segments, allowing 2 planning periods, 3 block students, on and on. If you look at the theater arts position, there's no sharing, no team playing. Let's see, 7th and 8th grades are mixed classes, no state testing accountability in that position. I can go on and on and on. Now, if you just do a comparison and contrast, the positions are not equivalent. She's been put into a non-equivalent position. And that's 20, and you know, that's why Mr. O'Hanlon's one of the finest lawyers. I have most respect for him and his opinions, but we just happen to, and I just happen to disagree with a level 2, level 3 opinion here. That's why we have horse races, because everybody thinks their horse is right. Okay, I'm representing my client. I think she's right. I believe that the school district administration think they're right. But that's why we have a court system. And you know why I believe in this country? Because this country is the finest country in the world, because we have the right to come over here and in front of this elected board be able to exhaust our administrative remedies in order to prevent costly litigation in the future that can come from these types of cases. Now, I'm here today in the spirit of that, and I'm trying to persuade this board that this matter can be simply resolved without costly litigation. But however, if the board does not make an accommodation, or if the administration sees it can't do that, then I just have to tell you we'll have exhausted our remedies and we'll move this to federal court. I hope that doesn't have to happen. I hope that isn't, because I believe that if you look at what happened, she took leave under family medical leave. She believed her position was going to be there when she came back. When she was informed, she was told by a secretary, I believe, of the school district that her job had been transferred to the theater arts without having the principal even tell her that she had been transferred. Now, you know, you think that if someone's going to be transferred from one position to the next, that a principal or somebody could pick up a phone and say, you know, Ms. Jones, you've been a dedicated employee. We believe that you've got, you know, you're under FMLA, but we're going to transfer you from English language arts over to the theater arts position, and this is why we're going to do it. That didn't happen. There was no communication. She got a call and was told by a secretary, which we appreciate the secretary telling her that, but that's not the way it'll work in this district or any district. She should have been explained to why that happened, how the jobs were equivalent. To this day, we've never been explained. I read the superintendent's opinion very carefully, and he basically sing-songs the fact that it's that the contract says that, you know, the educator can be transferred from one position to the next, and you know, that the pay is on the pay and all this. You know, but wait a second. FMLA says you can't transfer somebody to another position if it's not equivalent. It's not equivalent. The 2 positions are not. The job duties are totally different. The benefits may be the same, which we can see they are, but the statute says equivalent position with equivalent benefits. It's a two-test prong here. So what we're asking for is that she be reinstated under 29 USC. She has the right to have that reinstatement to her previous position in English language arts and reading in that classroom. She shouldn't have to go on FMLA leave and then come back and be changed, and there's no explanation other than we can do it because you're a classroom teacher. And you have a contract. But wait a second, President Clinton said that you can't do that if you're not back at an equivalent position. We're not asking for anything other than being fair here. It's okay to admit you're wrong every once in a while, because you know why? They put erasers on pencils. You know why? Because people make mistakes. And this was a mistake, because if you allow this to happen, then any other teacher or any other classroom or teacher or any other employee in this district is going to have a chilling effect. So that if they have a sick relative or they have to have medical treatment, then it's going to be okay for the administration to say, by golly whiz, you know what, we're going to go ahead and we're going to move you to another job. You know what, it's the same pay, same benefits, be happy about it. We're going to put you in a corner over here, and you're going to basically be looking at a computer terminal or taking a pencil and sharpening it the rest of your life. But you know what, it's the same pay.
Mr. Charbonneau, you
Yes.
have 2 minutes.
I got 2 minutes left. I just think that this is a type of situation where we really ought to stop and think about how would you want to be treated in a situation like this? If it was you or your loved one, or you had a person that was basically in the school district and was working here, okay? I mean, would you want to basically go on medical leave under FMLA and then have your job removed and then be told, you know what, it's okay. You know, you're getting paid the same money. Don't worry about it. All the work and everything you did and accomplished, we're going to move you somewhere else, and we can do that because the law says it's an equivalent pay, but it's not an equivalent position. So when you make this decision, we hope that you'll basically reinstate her back to her English language, arts, and reading position. We believe it's the right thing to do. We believe that it's not a hard decision. We're not asking for the world here, after all. I mean, we're just asking that she be put back into the job that she had before she asked for FMLA. That's what President Clinton passed this law. You know, and I think I agree with Bill Clinton. I'll agree with him. I mean, I can tell you I voted for him twice. You know, I'm not ashamed of it. And I'd probably vote for him again. But the bottom line is that we need your votes tonight in order to sustain what President Clinton believed was important. And I know that we can split hairs technically and legally on this issue. I know that. But, you know, why do we need to do that? Why do we have to go over to the federal courthouse for something like this? I mean, I'm going to have to if we're not able to get her reinstated or come to some compromise of some sort. But my client does not want to go to federal court against the school district. She respects Mr. Lamone. She respects everyone here. But she has to fight for what she thinks is right and also for every employee in this district. And that's why I'm up here. I represent workers. I represent people. That's what I was trained and taught to do. Thank you very much. Is that time, sir?
Anybody have any questions?
Thank you.
Yeah, I do. We started school August 27th, and I was looking here. It says that the date she was unable to work was from 8/20/2012 to 10/17/2012. So she still technically can't work, right?
She's been, I believe, she's going to be able to come back on October the 17th. Yes, ma'am. She's been cleared to come back on that date.
Okay, so technically this happened, we started school on the 27th. So it happened before that she wasn't able to be. So she would have been missing from the classroom for the first couple months of school.
Under FMLA, she would have been absent. That's correct.
And our students would have been left with what, Mr. Limon, with a sub until she got back? How much behind would these students have fallen if there was a sub in that classroom? Could our students be ready?
Is Mr. Wood here?
Sure am, sir.
Can you answer that question, Mr. Wood?
Sure can. 6 weeks of our lessons, we're in our 31st day, or 31st day today because we had yesterday off. So we'd be 6 weeks behind possibly with a substitute, not necessarily an ELA, language arts reading teacher as well. Whatever the district office would send us for a sub, and that could be anything.
So it could either be somebody who's actually very well in English or somebody who's just simply babysitting.
If we're lucky enough to get someone that's well versed, yes. If we're not, then yes, we'd be considerably behind. At our school, we missed AYT by 2 percentage points in language arts. Great.
In the past, just for reference, because I know that you referred to her using, getting ready for STAR and using the programs that we have. If I could ask, how many years had she been, or I don't know if I can ask you, how many years had you been a ELA, like?
That would have been my second year because I used to teach gifted and talented in McAllen.
Okay.
And I have an English major, so I'm very well educated in English and reading.
As far as like tax scores, do you all have what the tax scores were for the past 2 years?
I'd have to object to this line of questioning because that was not part of the record. And I believe that you're asking for information that's outside the record that's to be reviewed. Well, I object under school law precedent. I have to object to you asking questions that are outside the record. I don't believe tax scores were anything that was put into the record by administration or has been an issue.
Mr. O'Hanlon?
You can ask if he doesn't want to answer, then he doesn't want to answer. He's not required to answer the question.
I don't. First of all, I don't walk around with the tax scores in my back pocket. I think that Mr. Lamone may have that answer.
I asked my district to provide.
Mr. Wood wants to be recognized.
Mr. Wood, you have a comment?
Onto that, yes. When we looked at our averages last year, this is something we give the superintendent every May. We give a summary of each teacher by subject, by grade level, and if you're looking for an exact score, I'm not sure exactly how you want me to answer. I can answer it various ways.
Well, you said you don't have the exact.
Well, I have the exact.
Oh, you do have the exact?
I have an exact average roll-off score. Yes, I do.
You can give me that?
I sure can. 21.2.
Does the board have any other questions? Okay. Thank you, Mr. Shergill.
Okay, thank you.
Okay, do we proceed with the next grievance, or do we
Yes, let's go
deliberate?
ahead and call the next grievance. Let me set this one up, if you don't mind. It is 10/19 on October the 9th, 2012. We are here, the board is convened in open session at a lawfully called meeting to hear the level 4 grievance of Blanca Gonzalez. Would you introduce you generally? The board, you heard the previous authorizes about 10 minutes in presentation. I'll give you a warning if you will introduce yourself. I think the board knows your client.
Okay. And I would also ask for a 2-minute warning.
Yes, ma'am.
Good evening. My name is Cindy Garcia. I'm an attorney here in the Valley. I have an office in Harlingen and an office in Edinburgh, Texas. I know some of you. I've met you in the past. I am a resident of San Benito, and my daughter graduated from San Benito High School in 2004. I have the pleasure of representing Janie Gonzalez, who I've known for quite some time. And I know that you also are very familiar with Janie and the work that she's done here for the school district, probably a little bit over 18 years. Never been reprimanded, never had a problem with the school district, always done her job as best as she could. I think in this particular situation, and you can take a look at the record in front of you, I'm not going to go through and read or restate what we already have as part of the record. I hope that you have had the opportunity to read everything there and are familiar with what has gone on. I know the press is, and we've tried to keep out of the press as much as we could up until recently when they did contact me. I did have a few comments, but up until then I didn't really want Janie to respond to the questions the press had raised because I didn't want her to be tried in the press. I think that it would be fair for her to go through this process first and see if we could get it resolved with the school district, and if not, then proceed with exhausting our administrative remedies. One of the things that a couple of things to point out for the board, just in case you didn't know. Today I received a copy of the grievance that has been transcribed. And this was from the hearing that we held back in September. We had previously requested a transcription and were told that there was none available, and today we received a copy of the transcription. So just to let you know that this was our first opportunity to take a look at it to see how it was transcribed. And the other thing, if you look at the grievance decision, there are a couple things on the record that we noted, and one of them, and it's important because we want to make sure that the board is familiar with what school law is and what your parameters are and what you can and can't do, so that the school board doesn't run into any problems. One of the things is that The only things that can be considered at this particular level hearing are those things that were considered at the prior hearing. And because the only person that could make a decision with respect to Ms. Gonzalez's reinstatement was the superintendent, it would go to a level 3 instead of a level 1. And the superintendent then has the opportunity to designate someone to be the hearing officer. In this particular case, Mr. Limon designated Mr. Franco to be the hearing officer. Ordinarily, I probably wouldn't have a problem with having Mr. Franco being the hearing officer. But the fact that Mr. Limon was so close to the situation, and because he has stated that he would probably give testimony, that he should not be allowed to designate his designee to be hearing that level 3 hearing that we heard. And we did have an opposition to that on the record, and of course, we were overruled and the hearing went forward. In addition to that, we discovered after we received the decision that Mr. Franco based part of his decision based on conversations he had with Mr. Limon. In fact, it's referred to in his decision. He had conversations with Mr. Limon not only before the hearing, but after the hearing. And none of that was made part of the record. If Mr. Limon was going to come in and give testimony as to what his recollection of the facts were and what happened as conversations transpired between he and Ms. Gonzalez, then he should have come forward and given his testimony during that hearing, and he didn't. But he allowed the use of his designee to go informally and have discussions with him about Ms. Gonzalez and any conversations they may have had, and then use those in making his decisions, which are inappropriate and they violate school law. In addition to that, the hearing officer, Mr. Franco, attaches to his decision documents that were not introduced into the record. And there were some emails that were actually absconded from Janie's computer when she went into work one day and found out that all of her emails were completely gone from the computer. These 3 emails, or certain these emails, were part of that and were attempted to be attached to the record, which should not be attached to the record because they were not formally introduced into the record at the hearing, so should not be considered by this board, nor any of the comments that Mr. Limon made, unless they want to consider those comments he's made to the press, which are all have been made public. I think what's happened in this case is that Janie was caught between a rock and a hard place. You can't serve 2 masters, but she was asked to serve 2 masters. She was asked to do some things by the board and what they wanted, and then told by Mr. Limon she couldn't do certain things. And one of the most important things that he said she could not do was she couldn't speak her opinion on certain issues. The most important opinion she had was what was in the best interest of the school district and the employees with respect to insurance issues. That was the most important thing. There are other issues involving a letter, involving agents and things of that nature, but when Ms. Janie Gonzalez spoke out at a board meeting right before she got terminated, she was using her free speech to speak out on some issues, and that was being violated by Mr. Limon and pressing her not to talk to people, not to talk to the board. You're an elected officials. Janie Gonzalez is a paying taxpayer of the San Benito School District, and she should be able to talk to board members as a citizen and as a taxpayer of San Benito School District, and she was told not to. That's a violation of free speech, and in addition to that, what happens when she does try to speak up, she's retaliated against. She's never reprimanded. Although I've heard somewhere in the press or by rumors that Mr. Limon has told board members that he formally reprimanded Ms. Gonzalez prior to terminating her, that did not occur. There was a conversation that occurred between Mr. Limon and Ms. Gonzalez where he told her not to discuss with anybody, including the board, anything about anything else, including and specifically insurance matters. And that's what she did for fear of being terminated. And that's exactly what happened. So I think what you have in front of you is there's always going to be a dispute as to facts. That's why we're here. And our goal is to get Janie reinstated to her job. She knows how to do that job very well and has been doing it for a number of years. In fact, some of the duties that she's done in handling some of the insurance matters, the agent never even handled. Janie's been handling it all for all these years and has been doing it quite well, but the agent's been paid commissions for it. So I would ask that you consider reinstating Janie. We're trying to exhaust our administrative remedies. Hopefully we do not have to go to the next level, but we're prepared to do that if we have to. Everybody has an opinion. Everybody wants to say that they know what happened or that they've heard from people, or they want to use one excuse or another as to why Janie got terminated. The most important thing is it's all a pretext. Under the law, that's what it's called. It's called a pretext. And we don't have to prove beyond a reasonable doubt. That's in criminal law. We only have to prove by preponderance of the evidence, which is only tipping the scales a little bit. And that won't be much in Janie's case. But we ask you to consider reinstating her. That's what we're here for, and we're here to answer any questions you might have.
Questions?
Go ahead and ask him. Hold on.
Yes, ma'am, it says here that you had told your supervisor that what the board president had told you to do? Janie?
She's not going to answer. I'll answer for you. What was the question?
She had told her supervisor that the board president had told her to do something? The letter?
The letter.
The original, if you go back historically as to all this started, it started even before the letter, okay? But the letter comes into play where there are someone has made a decision that maybe the agent that was of record should no longer be the agent of record. And I don't even know how that happened, okay? So she gets told to write a letter, but I don't really believe that that's why we're here. It's part of some of the history of what transpired. I think why we're here is that, you know, Janie was retaliated against and was fired and wrongfully terminated. And we want to get her reinstated.
Did she ever tell Mr. Limon that she could go without an agent?
I believe that discussion did happen.
And what was Mr. Limon's response?
I think it's in the record. I think there were several discussions about that, and I think one of the things that is in the record is that she was told, or the question to her was, "Do you want to get me fired?" That was the response she got back.
There it says there too that there's two other people that heard it, right? That Mr. Limon said
Well,
that he could get fired if we could change agents.
I think it was on more than one occasion, and there were people that may have been present during one of the
And
conversations.
who were those two people that heard?
It happened on more than one occasion. I know on one occasion, it's my understanding that her direct supervisor may have been present.
Who's her direct supervisor?
I think it's Ms. McCall.
Ms. McCall? Ms. McCall, did you ever hear Mr. Limon saying that he'll get fired?
No, I did not.
Mr. Limon?
Mr. O'Hanlon, since they're claiming that I said certain things, can I address that?
Can you, if somebody asks you a question?
Okay.
Well, to the extent he's going to give any testimony, we're going to object to that since it's not part of the record, but
Board members ask you a question, you can answer.
Thank you.
It also says here in some cases that you don't need an agent. What are those cases?
I believe that there's a part of the insurance plan that is actually done in-house. I don't have all the particulars, but that's something that Janie was doing in-house, and there's no need to pay an agent commissions for the work that she was doing.
Can I ask, Mr. Limon, I have a question for you. On these commissions, do the district pay the commissions or the insurance companies?
The insurance companies pay the commission.
Okay, now, does the premium change because of these commissions? Are they higher or?
I don't know.
I think Mr. Garcia is here, right, Mr. Adrian Garcia? He might be able. Can we ask a question of our persons in
You ask your question, yeah.
Mr. Garcia, if I'm correct, the commissions are paid by the insurance companies, right? Now, does that change our premium as far as the district because of the commissions they're paying, or does that drive the price, or? I was told that it wouldn't. I've always heard that doesn't change the price as far as the premium for the district.
But you basically, you heard that it doesn't save the district anything if you do go with an agent, with or without, that it stays the same.
Now, we're talking about plans that are paid by the employee? Well, the employee pays the plans.
And-
There's really nothing saving for the district?
In other words, the commission doesn't have any impact on the premiums. That's what I'm trying to get at. That's what I heard by Mr.
Like when we went with the stop loss, and I said that I didn't want to go with an agent, because it was gonna save money, because we would be taking commission.
Right,
Was it saving the district money?
Yes.
It was saving the district money.
yes.
Got it. By going without.
I'd like to just say a few things as far as there is no insurance company other than the stop loss, which is already taken care of, that y'all took care of and saved $104,000. But we also have, you're also talking about the Blue Cross Blue Shield. We're talking about the administration fees. If we don't have an agent with Blue Cross Blue Shield, we could save $75,000. And I directly do all the work, used to do all the work for Blue Cross Blue Shield. Then there's a PTRX, which is your PBM, which is your prescription benefit management. That is $2.25 per month per employee commission to the agent as well.
I'd like
Jenny's
to,
no
I'd like
longer-
to, oh, go ahead.
Well, my thing, well, I can talk. My thing is that Janie isn't working for this district anymore, and yet she just informed the entire board of what's going on in our district and what we can save. So technically, I mean, kind of like she's still doing her job. She's still informing that what other people can't inform.
I think we're deviating from the grievance already. I have a question.
No, because we're gonna deliberate
Oh,
out here,
okay,
and we're gonna
okay,
make the decision.
okay.
So-
I'm gonna have a question for Mr. Limon, if he could address some of the concerns that were brought up. Mr. Limon.
What's the question?
The concerns that you brought up, that you had mentioned on Mr.
Yeah,
Limon,
what's the
of some of the
question?
sins that he had said. I know Mr. Limon could probably address them, and he said if we asked him that question, I'm asking him this question as a board member to address the concerns. that-
Right, what's
that
the
perhaps he has.
question?
Exactly, for him to address the concerns. That's
No,
all.
what's the question? I mean, I would object to him giving
Okay,
a
the-
narrative because he did not testify at the hearing, and according to school law, he's not allowed to get testimony. He can answer your question, but ask him a question.
Yeah. Conversations with Janie as per what the attorney was saying, is it true?
No, it's not. I never told Janie she couldn't speak to board members. All I told her was to inform me when she did.
And she already knew what your position was going to be because you made it pretty clear, Mr. Limon.
You were there, ma'am? The only issue here is that some emails were covered up, and that's it. She lied.
She couldn't go to talk to anyone because of your directive. And number two.
I never gave that directive.
Number two, Mr. Limon, you as a superintendent and anyone here at the school district, if they wanted to get something on a computer, they can get it. In fact, in May, you knew that some emails had gone out because you responded to an email directly saying, however that letter went out on the agent of record, that's how the letter has to go out to these other companies. So you directly knew, but now you're saying Janie hit him.
I had no knowledge that she had communication with those agents. I had no knowledge that that letter went out.
I know that's your position, and I know why, and I appreciate that. But instead, what's happened is a lower-level employee is a scapegoat.
Let me interject a couple of legal points here with respect to, at the risk of starting an argument. This is not a First Amendment case. Employees talking to boards about matters for which they are employed have no First Amendment rights. It's not a First Amendment case. The Fifth Circuit is absolutely bright line clear about that. This is not a First Amendment case. With respect to the grievance, this employee, there's no property right here. There's a liberty interest, and I've allowed some leeway here because you've requested a name clearing hearing, so we've trying to clear the air with respect to that at this public hearing. That's under a liberty interest, but there is no First Amendment freedom of speech issue in this case. With respect to the issue of employment, Ms. Gonzalez was an at-will employee. She is hired and subject to termination by the superintendent under duly adopted district policy. If you choose to do so, and you think that there's you can make a recommendation to the superintendent to undo that, but you cannot reinstate her. That would violate your own policies with respect to that, and his rights under 11.201D2 of the Education Code. So I wanted to make clear there's an allegation here that I'll address Mr. Shergold's point in a little while with respect to the Family Medical Leave Act as well, so I disagree with some of the things he said. But I wanted to interject in terms of what's out here right now, the legal position. So you have freedom to make recommendations to the superintendent, but be aware that those are recommendations. It is his authority.
Which almost makes this almost not worth going through when you think about it. But in any event,
Article 1, Section 27, and Chapter 11 of the Texas Education Code, as well as the liberty interest clause of the First Amendment, give you the right to have this hearing. But it does not change the substantive law with respect to who the employment authority is in the district.
At-will employment. It's like I tell my clients every day. Texas is an at-will state. You have a policy that says your employees are employed at will. They can fire you for any reason, no reason, a good reason, or a bad reason. But they can't fire you for an illegal reason. And I disagree with your counsel's statement as to whether or not my client's statements were made outside of her job performance or not. I think when she comes and speaks to board members and explained to you all what she thought should be done, she was doing it as a citizen here in San Benito, not necessarily as an employee of the school district. But I do believe that she's got the school district's interest at heart and always has. So I'll end it there unless anybody has any other questions.
Thank you, Ms. Garcia.
Thank you.
Ms. O'Hanlon, at this point, since there are no further questions, do we make a motion for a recommendation, whatever that may be, or?
Yes, let me address, if we're going to go on to that, let me address, give you my legal position with respect to Mr. Shergold's argument. It's his turn. With respect to my views on the Family Medical Leave Act, the act he quoted correctly says that you cannot change, you have to return them to a position of comparable responsibilities and benefits. The touchstone in here is as defined and is indicated by commissioners' decisions with respect to what the definition of professional capacity is teacher. Ms. Jones is fully certified to perform the functions of both the position she had and the one that she is assigned to. There is no reduction in salary or benefits under the district's pay schedule. There could not be. Teachers are hired and compensated in this district based upon years of experience, not upon classroom assignment. So their years of experience did not change. So there is no change in the salary schedule and her entitlement to salary or benefits. Under 11.202 of the Education Code, intra-campus assignments, this is not even the superintendent's call, assignments from one position or another to the campus are delegated by the Texas Education Code to the campus principal, not even to the superintendent. The campus principal exercised the authority granted to them under 11202, and absent a violation of the Family Medical Leave Act, which I do not see in this case because there's no diminution in salary or benefits, then I don't see a violation. Again, you're going to have to, you can make a recommendation in this case to the principal to do a reassignment, but you do not have the direct authority to do so yourself.
Board is requesting legal advice. Can they go back into executive session?
I just said do it out here and let's get it over with in terms of, I think I just did. No, somebody make a motion on one or the other cases. Or you can talk about them. I mean, I'm not trying to cut off your discussion.
That's fine. Well, from what I've heard tonight, you know, I believe that Ms. Gonzalez has done her job for 18 years. She's done it right. She has never had anything against her, like they had stated. I would understand if she had, you know, numerous things that were going wrong during her job. She's always remained professional and very truthful with the board when she's addressed us here at our meetings and any of, you know, board workshops that we've had. So she's never given me any reason, and I don't agree with the termination. So I make a motion to recommend to the superintendent that we reinstate Mrs. Gonzalez to her job with this district.
I second.
I have a motion on the floor right now to recommend to Superintendent reinstatement of Ms. Gonzalez by Ms. Aguilera, seconded by Mr. Huerta. I'd like to entertain that motion with a show of hands. All those in favor?
Aye.
All right. All those opposed? 4-3 motion carries. With regards to Ms. Jones' grievance, do I have a motion or a statement with regards to that?
If you want to discuss.
Mr. Dumont, if you can answer to me why you moved Mrs. Jones from the theater arts, or from the English to theater arts, or why that decision was made, you know, based off of what?
You need to ask Mr. Wood that.
Okay. That's fine. I mean, if you want to go up here, back up there, it doesn't matter. You're gonna have to straighten
There were times last year that my administrators and myself, we had met on numerous occasions, at least 2 or 3 times. I will leave it at that. We had discussed whether we were going to consider moving her at midterm due to some of the benchmark results that we had. You're asking the reason why we did at a later date. When our scores came in, the average score for our 6th grade reading was 29. And as I mentioned before, you asked what her average score was at that district. It actually gave a teacher average, it gave a district average. But for our 29. So the single kid, basically on the average, that's 29 correct. Which was 21.2 document that I gave Mr. Lee. I can answer.
Mr. Wood, did you hire Ms. Jones?
We hired her many years ago, yes.
And what
Last year was her first year that she taught English language arts for us. She just got certified last year.
What position did you hire her for?
Theater arts.
How many years did she teach theater arts for you?
Oh, boy, it's been a few. I'd have to guesstimate 6 or 7.
Thank you.
was told midterm, behind closed doors, with Mr. Wood and Mrs. Gonzalez, that I would be moved to breathing enrichment. Because my scores were different from the other two teachers on the team. Because they were much lower. That was based on the CISD 6-week test. It was not an official test. The 3 tests were different. I gave the complete test that was on the CISD curriculum, the complete test with everything. The other 2 teachers modified their test. They took out the difficult questions. I wanted to see where my students were at, so I kept in the more difficult questions. Yes, they did a lot worse. So behind closed doors, they said, we're going to move you to breathing enrichment unless you have the same scores as the other 2 teachers. So I said, that would be fine. I'll work really hard. The next test that was given, the benchmark, all 3 tests were comparable. There was maybe 2 percentage points of difference. So I kept my job. There was many complications that went on that made it very, very difficult for me to do my job. We were on a team of 3 teachers. We were supposed to be teaming and planning together. These 2 teachers did not share lesson plans with me. They did not speak to me. They sat with me at a table and ignored me. And so it made my first year in English language arts and reading a very, very traumatic experience and very difficult. And I fought very, very hard. I worked very hard to get this job. I took the test. I got a 98 on the test. I've taken English courses all my life. It's my favorite subject. I worked very hard for years to want to take this test. And I passed. And this is my passion, to teach reading and English. My father is a Pulitzer Prize nominated author, Dory Sherman. You can check him up on the website. He's won the Leitzer Award for writing about Texas Western. Okay, so this is my passion. This is what I want to do. I want to teach 6th grade English language arts and reading. And I did a very, very good job. And I worked very hard. So there was no reason for me to do my job.
Ill as a result of the year that I spent being shunned, bullied, harassed, kept out of the loop. I needed support. I needed Mr. Wood's support. I needed Mrs. Gonzalez's support, and I didn't get that.
And I have nothing, I don't know very well on anything to do. I think it's just for the sake of the children. They don't have instruction for 6 weeks.
But Mr. Wood had no way of knowing when I was coming back from medical leave, and this decision, I'm not sure when this decision was made, but there were 2 brand-new teachers with no tenure at Riverside that were hired without me coming back. He had no way of knowing when I was going to come back from leave.
And that's the thing, like, I mean, if he had no way of knowing, he wasn't going to know when you were going to come back. So
Okay.
it takes it to where, like, how long are these students going to be without? Is it going to be 6 weeks?
Exactly. Also, what they did was they got a substitute teacher based on, someone said I gave out the wrong handout sheet. So they got a substitute teacher, promoted her to instructional aide, and Mr. Wood told me simply, you didn't do what we asked you to do, so she's going to teach and you're going to monitor. You're just going to stand there in your room because I gave out a different handout sheet. That's what I was told. So they promoted this teacher as an instructional aide. So they have very qualified instructional aides. The teacher that took over when I was out is perfectly capable of taking those kids where they need to be. So that's not an excuse, that's not a reason not to put me back there. And I told Mr. Wood, I do not want to teach theater arts any longer. I'm moving on to a new career. I don't want to teach 7th and 8th graders. I want to teach 6th grade or elementary. And this is something I've wanted for a long time. So they're perfectly capable of promoting a substitute to instructional aid overnight. And this is a lady that had 20, 30 years experience. And there's many of those substitutes.
And if you would have been gone for a longer period of time, was it like to us that she would get moved up to, you know, an educational aid, and then when you came back, she would just get thrown down again, or she would?
I'm not sure what their plans would have been, but that's all here and there. That's all just speculation. So there was no way of them knowing that. And those teachers, I'm not sure when they were hired. He didn't know when I was coming back. I could have come back day one. My position was moved. 2 new teachers were hired. I was on Family Medical Leave Act. That protects me to keep the same duties. I want those duties that I had. I don't want to teach an elective anymore in this district, in this school.
I would just like to state that I think it's, you know, from a fairness point, for Mr. Wood to be able to come up here and, I guess, denigrate my client's teaching ability through one test score, I object to that. That was never part of the record. And why didn't he tell her that when he made the decision to transfer her? He never picked up the phone or never even called her into his office. He waited to come up here on 9 October 2012 and tell you the reason. She's been waiting to hear that for the last 4 or 5 months. That's fundamentally unfair. Thank you very much.
Thank you. Okay. Does the board have any other questions, comments? Okay, do I have a motion for the Jones grievance? Okay. Being that there's no motion, no action will be taken on the level 4 grievance for Gina Jones, and the administrator decision will be upheld?
Under district policy DGBA local, if the board takes no action, the effect will be to uphold the decision at level 3.
So that means Mr. Lamone's decision is upheld?
Pardon me?
That means that Mr. Lamone's decision is upheld? Is that what it means?
Yes.
All right, thank you. Good evening.
Which brings us on to item number 11. The time is 11 o'clock, and meeting is adjourned.